There are different strategies, of course, which all of us can adopt when it comes to multi-jurisdictional patent portfolios and maintaining those global portfolios. But what are some of your observations, again, specifically to your jurisdictions, which you have observed, or common pitfalls which applicants should, or the foreign patent lawyer should be aware about when specifically enter the national fees applications in your country? From the prosecution standpoints, we have of course spoken already about the sufficiency disclosure, the law of the land, but what are some of the hidden things which very few people do know about your local jurisdiction, which they must while designating your countries? Do you want to touch upon that as a topic, as a point? Anything specific for India, Suchi?
So I think one part I had just covered, which was about specially method for treatment claims, because there is a big furor about it. There are quite a few applications which have gone down the drain, some of which were repealed and could stand the test of time, so the courts actually ultimately gave a positive decision. So one piece of advice would be that when you're filing, while it is mandated by law, that your claims have to be identical with what was filed before the PCT office. It always helps to actually see if there's any sort of amendment that is required that you should file immediately thereafter, if at all it falls in any subject matter which is excluded. That being one. The second thing I think largely that we have to keep in mind is that I think to a great extent I could say that Indian law is catching up a lot. So till some time back, divisional applications were not allowed in India. So essentially, unless and until you had a second set of claims in the application, could you only divide that out later on if there is an objection from the patent office, or voluntarily also, only if the claims were there initially. But now, with some changes recently, the divisional applications could be something which are required. I think a lot of the things in India which are catching up when it comes to US and European practice are before the courts. But largely my point would be that please do get your claims vetted. And if there is a requirement of amendment, it's better not to wait for the office action, but file form, amendment form or request and make respective changes. But one important thing, post the decision which is grant, is that India has this requirement of submission of working of patent, which if not being complied with, has great ramifications. So that is something I don't think is there out there in US or Europe as a necessary or mandatory step to be taken. But from the Indian context, that's important. That is mandatory.